All right, you guys, welcome to Lone Wolf Pack. Welcome to another podcast today. I am your host, Patrick, and I am going to be, we're going to be going over some things today that I hope everybody's going to think are cool. I always think this stuff is cool. So we're going to be going over express trusts, basically express trusts. And we're going to be talking about how express trusts are something that we should all express. We're all having an expression party. So yeah, pretty cool stuff. Anyway, we're gonna talk about some interesting things today. I need to bring up a document that I need to save real fast. And let me show you, I'll show you guys right here. And let's remove this so you guys can see me now. Okay, welcome guys. Welcome everybody. I'm kind of just right now I'm going through the presentation so I can show you guys and bring something else up on here. I need to stop some things and I don't know how to use this whole thing yet. So we're going to I'm going to improvise. Let's go to present. Let's go to screen share. I didn't have this as, I guess I could do this as a presentation and slideshow from the beginning. And I need to remove this. Sorry, guys. I'm having to go through this and kind of show you guys some stuff. Share screen. I don't need to share anything that is, there we go. This is what we need to share. Okay, so we're gonna talk about unveiling secrets behind trust and their creation formalities. We're going to talk about some things that are pretty interesting. I think everybody should get involved in understanding exactly what this stuff does and why it exists the way it does, because we're all here to learn. We're all here to expand our knowledge. And the only way we can do that is if we understand what we're talking about, if we know what we're talking about. So let me get started here. The information in this podcast is for informational and educational purposes only. It's not intended to provide legal advice and should not be construed as such. Listening to this podcast does not create an attorney-client relationship between you and the host. For legal advice, please contact a qualified attorney who can provide you with legal counsel tailored to your specific circumstances. And that is what I have to say. And this is just for Tito, because Tito is an amazing man. Well, I guess not. That's not coming through. And I don't know why. But anyway, that's the viewer discretion. So the information, I know why it's not coming through, because I still have this fader out on here. Hold on just a second. Okay, so let's try this again. This is for Tito.
The following program contains mature content and is the truth. No part herein is intended to be legal advice and is for entertainment purposes only. Audience discretion is advised.
All right, welcome esteemed viewers to another podcast of Lone Wolf Pack. And we're going to delve into the intricacies that impact your life, legacy, and wealth. And I'm your host, Patrick, and today we're expanding the enigmatic world of express trusts. Whether you're aspiring legal eagle, a trustee, a settlor, or someone keen to protect their assets, this episode is for you. And by the end of our discussion, you'll be equipped with knowledge to understand, create, and effectively manage an express trust, ensuring that your intentions are preserved and that beneficiaries are safeguarded. So let's go through this, and I'm going to try to present this to you guys. All right. So the diagram... this diagram here illustrates the fundamental components of an express trust, including the relationship between settlor, trustee, and beneficiaries. Okay, let's begin with the basics. Trusts have been a cornerstone of property law since the inception during the medieval period. In fact, before that, originating in England, and I don't know that we can get an exact day or exact time when it was even created. I know that they have origins that are indicative of being in England, and this is through crusades. The concept of trust allowed knights to leave their lands in the hands of a trusted individual while they embarked on perilous journeys. This individual or trustee was entrusted with managing the property for the benefit of the knight's family, a practice that has evolved into the sophisticated legal tool we now refer to as an express trust. The foundations of an express trust, and to fully appreciate the significance of it, one must understand the key elements that constitute its foundation. According to Pomeroy's Equity Jurisprudence, 5th edition, sections 997 and 998, published in 1941, the creation of an express trust requires three essential elements, often termed the Three Certainties. These certainties are the certainty of intention. The settlor must clearly express the intention to create a trust. This intention must be unequivocal, leaving no doubt as to the settlor's desire to establish a trust. The intention can be articulated in writing, typically through a trust deed, or verbally in certain circumstances. For instance, a statement like, "I wish for my property to be held in trust for my children," clearly establishes this intention. Number two is the certainty of subject matter. The assets to be held in the trust, known as the trust property or res, must be clearly defined. Vague statements like, "I want my assets to be in a trust," are insufficient. The settlor must specify the exact assets, whether it be a specific piece of real estate, a portfolio of stocks, or a collection of rare art. Failure to clearly define the subject matter could render the trust invalid, as the trustee would not have a clear understanding of what is to be managed. Number three is the certainty of objects. The beneficiaries of the trust must be clearly defined. The law requires that the beneficiaries be ascertainable, meaning they must be specifically named or otherwise clearly defined. Ambiguous designations like "for the benefit of worthy people" are problematic, as they leave too much room for interpretation and could result in legal disputes. The infographic visually represents the three certainties necessary for formation of an express trust, including intention, subject matter, and objects. These certainties are crucial because they form the bedrock upon which an express trust is built, and without them, the trust could be deemed invalid, leading to significant legal and financial complications. The formalities associated with the creation of an express trust are not merely procedural. They are foundational to the trust's validity and enforceability. These formalities include, number one, a written document. In most jurisdictions, a written document is required to establish an express trust, particularly when it involves real estate or significant assets. This document is often called a trust deed, outlines the terms of the trust, including the identity of the trustee, the beneficiaries, and the assets included in the trust. The statute of frauds and the legal doctrine dating back to 1677 mandates that certain types of agreements, including those involving land, must be in writing to be legally enforceable. The trust deed is akin to a legal blueprint, guiding the trustee in their management of the trust and ensuring that the settlor's intentions are honored. The importance of this document cannot be overstated, as it serves the primary evidence of the trust's existence and terms. Number two is the transfer of assets. For a trust to be effective, the settlor must transfer the assets to the trustee. The transfer can take various forms, such as transferring the title of real estate, registering shares in the name of the trustee, or physically handing over valuables. The act of transfer solidifies the settlor's intention and legally vests the trustee with control over the trust property. If the assets are not properly transferred, the trust may fail, leaving the beneficiaries without the intended protection or benefit. Number three is acceptance by the trustee. The trustee must formally accept their role and responsibilities. This acceptance can be explicit, such as signing the trust deed, or implicit, which means through actions like managing the trust property. If a trustee does not accept the role, the trust may be left in a state of limbo until the new trustee is appointed. This process can involve the court, which may step in to appoint a trustee, potentially leading to delays and complications. Number 4 is compliance with legal requirements. Different jurisdictions may have additional requirements for creation of trusts, especially when it involves specific types of property or complex assets. For example, in some jurisdictions, trusts that involve real estate must be registered with the local land registry. And additionally, certain assets like shares in a corporation may require specific procedures to transfer ownership to the trustee. If you don't comply with these requirements, it can result in a trust being declared invalid or unenforceable. This visual highlights the common pitfalls associated with creation of management of trusts, including the failure to transfer property, overly complicated terms, and ignoring implications. The successful operation of an express trust hinges on the roles and responsibilities of key players involved: the settlor, the trustee, and beneficiaries. Number 1, the settlor. The settlor is an architect of the trust, responsible for establishing the trust's framework and terms. This role extends beyond the creation of the trust, as the settlor may retain certain powers, such as the ability to amend the trust terms, appoint or remove trustees, or revoke the trust entirely. However, these powers must be exercised judiciously to avoid undermining the trust's independence. If the settlor retains too much control, the trust may be considered a sham, leading to potential legal challenges and legal implications. This is one thing that is prevalent in the secured party creditor trusts, because the settlor retains too much control and they can consider all of those trusts a sham, especially if you haven't conveyed that property. And I don't mean just by saying it's on a UCC1. So there's a lot more to learn on this, folks. Number 2 is the trustee. The trustee is the steward of the trust, entrusted with managing the trust property and ensuring that the settlor's intentions are fulfilled. This role carries significant fiduciary responsibilities, including the duty of loyalty, prudence, and impartiality. The trustee must act in the best interests of the beneficiaries, managing the trust assets with the same care and diligence as they would manage their own property. The trustee's fiduciary duty also requires them to avoid conflicts of interest. If a conflict arises between the trustee's personal interests and their duties to the beneficiaries, the trustee must resolve the conflict in favor of the beneficiaries or step down from their role. Okay. The duty of impartiality is particularly important when there are multiple beneficiaries with differing interests. And so number 3 is the beneficiaries, and they're the ultimate recipients of the trust's benefits. They have the right to be informed about the trust's experience or existence and terms. Their rule book, in other words. They receive distributions as specified in the trust deed and hold the trustee accountable for their actions. Beneficiaries can be categorized in 2 main types. There are income beneficiaries who receive the income generated by the trust assets, and remainder beneficiaries who receive the trust property upon the termination of the trust. The relationship between the trustee and beneficiaries is governed by the terms of the trust deed, but is also influenced by equitable principles that ensure fairness and protect the beneficiary's rights. As we delve deeper into the world of express trusts, it's important to explore some of the more advanced concepts that can influence the creation, administration, and termination of trusts. Number 1 is secret trusts. A secret trust is a type of express trust where the terms are not fully disclosed in a will, but are instead communicated privately to the trustee. This arrangement is often used to ensure privacy or discretion in bequests, particularly in cases where settlor wishes to provide for a beneficiary without public disclosure. Secret trusts can be classified into 2 types, and these are typically what celebrities will use or politicians, especially if they have children from other relationships that are not public relationships, and they don't want people to know. Secret trust can be classified into fully secret trust, where the existence of the trust is not mentioned in the will, and half-secret trust, where the will mentions the trust but does not disclose the details. Secret trusts pose unique challenges as they rely heavily on the trustee's integrity and the absence of formal documentation. If a trustee fails to honor the terms of a secret trust, the beneficiaries may have limited legal recourse, particularly if the trust's existence is disputed. Number 2 is constructive trusts. While not an express trust per se, a constructive trust is an equitable remedy imposed by the courts to address situations where it would be unjust for a person to retain property. Constructive trusts often arise in cases of fraud, breach of fiduciary duty, or other wrongful conduct. For example, if a trustee wrongfully profits from their position, the court may impose a constructive trust, requiring the trustee to hold the profits on behalf of the beneficiaries. Constructive trusts are a powerful tool in equity, allowing courts to prevent unjust enrichment and ensure that property is used for its intended purpose. A resulting trust is another, and this is the third, is another equitable concept where the property returns to the settlor or their estate because the trust fails or does not dispose of trust property. This can result when the trust's purposes are incomplete, or there's an excess of property after the beneficiary's needs have been satisfied. Resulting trusts are typically presumed in situations where the intention of the settlor is unclear, but equity dictates that property should not remain with the trustee. Resulting trusts underscore the importance of clearly defining the terms and purposes of a trust, as any ambiguity can lead to unintended consequences and the reversion of property to the settlor or their heirs. Understanding the evolution of trust law and examining key cases provides valuable insights into how express trusts are applied and interpreted in different contexts. Let's see here. All right. Oh, this is the wrong one. We need to go back to here. So this is historical context. We're going to talk about some of these. This early case is often, and this is Aerosmith versus Burlingame, Burlingim. This case is often cited in discussions about enforceability of trusts. It highlighted the importance of clear and precise terms in the trust deed, as well as the court's role in ensuring that trusts are administered according to the settlor's intentions. The case underscored the need for three certainties and demonstrated the consequences of ambiguity in trust terms. Number 2, we have the Rockefeller trusts. John D. Rockefeller's use of express trusts to manage the preserve his family's wealth is a classic example of how trusts can be used to achieve long-term financial and, hear the word, philanthropic goals. The Rockefeller Trust is not only provided for the financial security of the descendants, but also funded the creation of major institutions like University of Chicago and the Rockefeller Foundation. These trusts illustrate the versatility of express trust in managing large estates and supporting charitable endeavors. Number 3 is the Walt Disney Family Trust. Walt Disney's insight in establishing a family trust made sure that his intellectual property would be protected and continue to generate income for all of his descendants. The trust included specific instructions on managing Disney's creations, making sure that they would be preserved and remain a source of financial security for his family. And this highlights the importance of planning in the future, particularly when dealing with valuable intellectual property. So we have the Lehman Brothers bankruptcy. The collapse of the Lehman Brothers in 2008 is a cautionary tale about the importance of property structuring and managing trusts. The legal battles that ensued over their assets, many of which were held in trust, underscored the need for a clear trust terms and proper administration. Lehman Brothers also highlighted the complexities involved in managing trusts that contain diverse and high-risk assets. Creating an express trust is a complex process that requires planning and attention to detail. If you fail to address key issues, it can lead to legal disputes, financial losses, and the invalidation of the trust. The Lehman Brothers. So we when we talk about that, some of the pitfalls that we need to avoid. Okay, these are pitfalls that we should avoid, and how to avoid them. So lack of clarity in the trust document, ambiguity, which is vagueness in the trust document, can lead to endless legal battles. So the case of Knight versus Knight in 1840 is a prime example of this pitfall. The court had to determine the validity of a trust based on the clarity of its terms, ultimately establishing the Three Certainties rule. To avoid such issues, it's crucial for the settlor to work with an experienced somebody who can work with trusts for you and can ensure that the trust document is clear, precise, and comprehensive. So the second one is failure to transfer property to the trust. As I mentioned earlier, the trust cannot function without the transfer of assets to the trustee. This step is often overlooked, particularly when dealing with a complex or intangible assets like intellectual property or stocks. In a case called Milroy versus Lord, 1862, it illustrates the consequences of failing to properly transfer property to the trust. The court ruled that equity will not perfect an imperfect gift, making that if the legal transfer of property does not occur, the trust cannot be enforced. To prevent this issue, the settlor should ensure that all necessary transfers are completed at the time the trust is created. This may involve signing deeds, registering shares, or transferring intellectual property. Number 3 is overly complicated trust terms. While it's tempting to plan for every possible scenario, overly complex trust terms can be difficult to administer and lead to disputes. The case of Howard Hughes, the eccentric billionaire who serves as a warning. Hughes left behind a complex web of trusts, but the terms were so convoluted that it led to years of legal battles. The lesson here is that simplicity often leads to better outcomes. The trust document should be clear and manageable, allowing the trustee to administer the trust without unnecessary complications. Number 4 is ignoring tax implications. Trusts have significant tax consequences, and failing considerations can lead to unexpected liabilities. Different types of trusts, like revocable trusts, irrevocable trusts, and charitable trusts, have different tax treatments. For example, the generation skipping transfer tax, GSTT, applies when assets are transferred to a beneficiary who is 2 or more generations younger than the settlor, which, as a grandchild, if not properly planned, the GSTT, the generation skip transfer tax, can significantly reduce the value of the inheritance. The estate of Rockefeller is a prime example of successful tax planning. The Rockefeller trusts were structured to minimize the estate taxes and preserve wealth across generations. Without such planning, a significant portion of the estate could have been lost to taxes. Number 5 is failure to appoint or failure to account for future changes. Life is unpredictable, and a trust that works well today might not be suitable in 10 years. Changes in family circumstances, tax laws, or financial conditions can impact the effectiveness of a trust. In Clayton versus Ramsden, Ramsden, 1943, illustrates this point very well. The court had to interpret a trust condition that was no longer relevant due to the changes in social attitudes, ultimately rewriting the trust to sign with current laws and social norms. To avoid this pitfall, the trust document should include provisions that allow for amendments and adjustments in response to future changes. This might involve giving trustee discretionary power to adapt the trust or including trust protection, who can make necessary changes. As we look into the future, it is clear that express trust will continue to be a tool in estate planning, wealth management, and philanthropy, which is like charitable things, okay? Trusts. However, the landscape is evolving and new trends are emerging that could reshape how trusts are used and administered. Number one is digital assets. The rise of digital assets as cryptocurrencies, NFTs, and online businesses presents new challenges for trust law. Traditional trust documents may not adequately address these assets, leading to confusion and potential loss of value. As these assets become more common, we're likely to see new legal framework and best practices for including them in trusts. For example, if a settlor owns significant cryptocurrency holdings, the trust document needs to specify how those assets are being managed, how they're being transferred, and how they're being protected. Without clear instructions, the trustee may struggle to access or properly handle these assets, particularly given the complexities of digital wallets, private keys, and blockchain technology. Globalization and cross-border trust. As families and businesses become increasingly global, cross-border trusts are becoming more common. And these trusts involve assets or beneficiaries in multiple jurisdictions, creating complex legal and tax issues. So differences in trust law, tax treaties, and reporting requirements can complicate the administration of cross-border trusts, making them a challenging but necessary tool in the global economy. For instance, a trust with assets in the United States, beneficiaries in the United Kingdom, and a trustee in Singapore would need to navigate the legal requirements of all three countries. It might involve complex tax planning to avoid double taxation, ensuring compliance with anti-money laundering laws, and dealing with currency exchange issues. Number three is environmental and socially responsible trusts. As awareness of environmental and social issues grows, more settlers are using trusts to promote sustainability and social responsibility. These trusts might include conditions that require the trustee to invest environmentally friendly companies, support charitable causes, okay, that's the second category, or avoid industries that harm the environment, another category. This trend reflects a broader shift towards socially responsible investing in philanthropy. For example, a trust might be established with a mandate to invest only in companies that meet specific environmental, social, and governance criteria. The trustee would then be responsible for ensuring that the trust's investments align with those values, which might involve divesting from certain industries or actively engaging with companies to promote better practices. Number four is technological advancements in trust administration. Technology is transforming how trusts are administered, from the use of blockchain for secure and transparent reading or record keeping to artificial intelligence to optimizing trust investments. These advancements offer new opportunities for efficiency and accuracy, but also raise questions about privacy, security, and the role of human judgment in trust management. Blockchain technology, for example, could be used to create a transparent and immutable record of the trust transaction, reducing the risk of fraud and improving accountability. Meanwhile, AI algorithms could help trustees make more informed investment decisions by analyzing vast amounts of data and predicting market trends. However, the use of such technology also requires careful consideration of cybersecurity risks and the need for human oversight. Moving forward, we have, all right, so I'm going to show you that at the end because we're not done there. All right, so creating express trust, concluding things here, is like assembling the ultimate legal puzzle. Every piece, intention, property, and parties must fit together perfectly to create something that lasts. By understanding the formalities and rules involved, you can create a trust that not only serves as its intended purpose, but also stands the test of time. Whether you're managing family wealth, planning for future generations, or supporting a cause you care about, an express trust can be the ideal vehicle to achieve your goals. As we've discussed today, the creation of express trust involves several crucial steps, from ensuring that the three certainties to carefully draft the trust document and transferring assets. Each one of these steps must be handled with a deep understanding of the legal requirements and potential pitfalls. Whether you're a settlor, trustee, or beneficiary, it's essential to know your rights, responsibilities, and long-term implications of the trust arrangement. For those considering establishing an express trust, remember a professional advice is indispensable. Engage with professionals who can guide you through the complexities of trust creation and administration. They help you navigate the landscape, anticipate future challenges, and structure things in a way that meets your specific needs. If you're already involved in a trust, whether as a trustee or beneficiary, stay informed and proactive. Trustees should regularly review the trust's performance, consult with experts as needed, and ensure that their actions align with the trust's terms and the best interests of the beneficiaries. Beneficiaries, on the other hand, should understand their rights under the trust and communicate openly with the trustee to ensure their rights are protected. Finally, express trusts are not merely constructs, they are instruments of legacy. Whether you seek to protect your family's future, support a charitable trust or charitable cause, or ensure your life's work continues to benefit others, an express trust can be the way to achieving these goals. Thank you guys for joining me today on Lone Wolf Pack Podcast. Until next time, I'm Patrick. Stay legally savvy, stay spiritually savvy, and remember, when it comes to your legacy, trust is everything. Again, this information is provided in this podcast is for educational and informational purposes only. It does not constitute legal advice and should be relied upon as such. If you require legal assistance, please consult a qualified attorney who can provide guidance based on your individual circumstances. The views expressed in this podcast are those of the host and not necessarily reflect the opinions of any affiliated organizations or affiliates of the private trust. You guys have an amazing day. I appreciate you so much. And with that, I yield.